Now let's talk about work. And this domain is different in a way you should feel immediately. Everywhere else, we've talked about consumers who can walk away. Employees cannot. That power asymmetry shapes everything. 5 focus areas. First, the conceptual frame. What privacy expectations do American workers actually have? Spoiler, fewer than they think. And why is workplace privacy governed by federal and state law so unevenly? Second, hiring. FCRA in employment screening, background checks, and the constraints from the ADA and Title VII, plus polygraph and drug testing limits. Third, monitoring. Email, internet, devices, video, location, biometrics. What can an employer watch and where are the lines? Fourth, the modern workplace. BYOD, remote work, social media, where the boundary between personal and professional dissolves. And fifth, the end of the relationship. Investigations, whistleblowing, employee records, termination, and what happens to data after someone leaves. This is a domain where practice and law diverge sharply. Let's see why. Let me start with the sentence that shapes this entire domain. In the American workplace, the employer's property and the employer's interests dominate. Why? Two reasons. First, the Constitution. The Fourth Amendment restrains government, so a public sector employee has constitutional protection against unreasonable searches by their employer because their employer is the government. A private sector employee has none. Same conduct, completely different analysis. Second, at-will employment. Absent a contract or a statute, employment can end for any reason or no reason. So an employee's leverage to demand privacy is close to zero. The legal test that does exist is reasonable expectation of privacy. And here's the trick. That expectation is largely created by the employer. Publish a policy saying all systems are monitored, have employees acknowledge it, display login banners, and you've eliminated the expectation. The policy doesn't just describe reality, it manufactures it. So think about what that means. A locker with a personal lock might create an expectation. A company email account with a monitoring banner does not. I once had a client whose employees sued over email monitoring. The case collapsed on one exhibit, a signed acknowledgement from onboarding. Here's what I want you to sit with. Do most employees actually understand this? In my experience, no. They assume a bathroom stall level of privacy at work. The law assumes the opposite. So where does workplace privacy law actually come from? Because there's no federal Workplace Privacy Act. What we have instead is a patchwork of federal statutes that touch privacy sideways. FCRA, when you run a background check. ADA, restricting medical inquiries. Title VII and GINA, restricting what you can ask and use. ECPA, which restricts interception but has enormous employer exceptions. The Employee Polygraph Protection Act. The NLRA, protecting concerted activity, which reaches social media policies in ways employers rarely anticipate. OSHA, FMLA. Notice, none of them are privacy laws. They are employment laws with privacy consequences. States fill the gaps, and aggressively. Some states have constitutional privacy rights that reach private employers. California is the standout. Some require notice before monitoring. New York requires written notice of electronic monitoring at hiring. Connecticut and Delaware have similar rules. Some restrict social media password requests. Some restrict off-duty conduct discipline. Some, like Illinois, regulate biometrics with a private right of action. And then California did something unusual. It extended CCPA to employees. So an employee in California has access, deletion, and correction rights against their own employer. Think about that. Everywhere else, employees are consumers only after they leave. Where's the action? States. Same story as every other domain. Here's a fact that surprises people. FCRA governs hiring, not just lending. When you hire a third party to run a background check, that report is a consumer report, and the screening company is a consumer reporting agency. So FCRA applies fully, and it imposes a specific sequence you must follow exactly. Before you procure the report, you need a clear and conspicuous written disclosure. And critically, it must be in a standalone document, not buried in the application, not combined with a liability waiver. Courts have punished employers severely for cluttering that document. Then you need written authorization from the applicant. If the report leads you toward an adverse decision, you must do a two-step. First, a pre-adverse action notice. Give them a copy of the report and a summary of their FCRA rights. Then, wait a reasonable time, typically around 5 business days. Then, if you proceed, a final adverse action notice identifying the CRA, stating the CRA didn't make the decision, and explaining their right to dispute. Why the two-step? Because the report might be wrong. This is their chance to say, "That's not me," or "That charge was dismissed." And investigative consumer reports, which involve interviews about character and reputation, carry additional disclosure duties. Here's the practical point. FCRA class actions against employers are common, and they're rarely about bad decisions. They're about paperwork. Let's stack the other statutes on top, because FCRA isn't the only limit. The ADA is strict about sequence. Before a conditional offer, no disability-related inquiries and no medical examinations. None. You can ask whether someone can perform essential functions with or without reasonable accommodation. You cannot ask about their conditions, medications, or history. After a conditional offer, you may require a medical exam, but only if you require it of all entrants in that job category. And if you withdraw the offer based on it, you need job-relatedness and business necessity. Once employed, inquiries must be job-related and consistent with business necessity, and medical information must be kept in separate confidential files, separate from the personnel file. That's a specific statutory requirement people forget. GINA prohibits requesting or using genetic information, and that includes family medical history, which is why medical inquiry forms need safe harbor language warning providers not to send genetic information. Title VII adds the disparate impact problem, a neutral criterion that disproportionately excludes a protected group can be unlawful unless job-related and consistent with business necessity. Criminal history screening is the classic example. Ban-the-box laws build on this. Let me leave you with the framing. The ADA is about timing. GINA is about category. Title VII is about effect. Two more pre-employment topics, and they behave very differently. The Employee Polygraph Protection Act, 1988, and this one is unusually clear. Most private employers may not require, request, suggest, or cause an employee or applicant to take a lie detector test. They may not use the results. They may not discriminate against someone who refuses. The exceptions are narrow. Federal, state, and local government employers, certain national security contractors, security services firms, pharmaceutical manufacturers and distributors handling controlled substances, and an ongoing investigation exception with strict conditions where there's economic loss and reasonable suspicion. Notice how tight that is. Congress essentially decided polygraphs don't work and shouldn't be used. Drug testing is the opposite, largely permitted, heavily state variable. Federal contractors face Drug-Free Workplace Act obligations. DOT-regulated positions have mandatory testing. Beyond that, it's state law. And cannabis has broken the whole framework. Legal in many states, still federally illegal. Some states now protect off-duty use. Some prohibit adverse action based on a positive test alone, absent impairment, which creates a genuine mess. A THC test detects past use, not current impairment. You can test positive from 3 weeks ago. So ask yourself, what is the test actually measuring, and is that what you care about? Increasingly, the law says no. Now let's get to the daily reality, watching. ECPA governs interception, but it has two exceptions that swallow most of workplace monitoring. The business extension exception, interception through equipment furnished by the provider and used in the ordinary course of business. So company email, company phones, company systems, largely covered. The consent exception, one-party consent under federal law, and employers manufacture consent through policies and banners. But watch the state overlay because it matters. Some states require all-party consent. California, Florida, Illinois, Pennsylvania, Washington, and others. So a call recording that's fine under federal law can be criminal in California. And the Stored Communications Act adds a wrinkle. Accessing stored messages is different from intercepting them in transit. Courts have found employers liable for accessing an employee's personal webmail using credentials saved on a company device. That's not your system. Furnishing the laptop doesn't furnish access to Gmail. What's the practical rule? Monitor systems you own for legitimate business purposes with clear notice. Do not go fishing in personal accounts. Here's the case that stuck with me. An employer read an employee's messages in a private online group by using a co-worker's login. Court was not amused. So the line is this: ownership plus notice is your shield. Neither one alone is enough. Let's escalate the intrusiveness because the rules escalate too. Video first. Generally permitted in open work areas with notice, but there are absolute lines. Restrooms, locker rooms, changing areas. Some states criminalize it outright. And the NLRA matters because surveillance of union activity is an unfair labor practice. Even installing a camera in response to organizing can violate the act. Audio is different from video. Adding sound recording pulls you into wiretap statutes, and the all-party consent states apply. A camera is one analysis. A camera with a microphone is another. Location. GPS in company vehicles is generally permitted with notice, but off-duty tracking is where it breaks. There's a well-known case of an employee fired for disabling a tracking app that monitored her 24 hours a day, including weekends. That's not monitoring work, that's monitoring a person. Biometrics is the sharpest. Fingerprint time clocks, facial recognition for access, voice prints in call centers. And Illinois BIPA changed the economics entirely. Written notice, written release, a retention schedule, and a private right of action with statutory damages per violation. Employers have paid enormous settlements over fingerprint time clocks. Think about the risk asymmetry. You installed a time clock to stop buddy punching. You created 9-figure exposure. Was it worth it? Now the modern mess. Where does work end and life begin? BYOD first. The employee owns the device. The employer owns some data on it. That's an inherently unstable arrangement. The tools are mobile device management and containerization. MDM can be aggressive, potentially wiping the whole device. Containerization separates work data into an encrypted space you can wipe independently. Always prefer containerization. Because remote wiping someone's phone and destroying their family photos is a lawsuit waiting to happen, and it has happened. And litigation holds get strange. Discovery reaches relevant data wherever it sits. If work messages are on a personal phone, that phone is potentially discoverable. Remote work adds more. Webcams in bedrooms, household members in frame, home network security, productivity monitoring software taking screenshots every few minutes. Social media. Most states now prohibit demanding passwords to personal accounts, and the NLRA protects concerted activity. So, a policy prohibiting discussion of working conditions online is unlawful, even in a non-union workplace. The board has struck down countless overbroad policies. Here's the question I put to every client drafting these. If an employee complains about their manager on Facebook and two co-workers agree, is that misconduct or protected activity? It's protected, and that surprises almost everyone. Let's talk about what happens when something goes wrong internally. Workplace investigations involve real privacy tension. You need to interview witnesses, review communications, sometimes search workspaces. And you need to protect the complainant, the accused, and the process. Confidentiality is where employers stumble. The instinct is to tell everyone, don't discuss this. But blanket confidentiality instructions can violate the NLRA because employees have a protected right to discuss workplace conditions. The board has required a case-by-case justification, witness protection, evidence integrity, risk of retaliation. And the accused has interests too, notice, an opportunity to respond, and in some states, access to the investigation file. Whistleblowing has its own protections. Sarbanes-Oxley for public companies, Dodd-Frank for securities, False Claims Act for government contractors. And these protect the whistleblower from retaliation, which includes surveillance. Monitoring someone because they filed a complaint is itself retaliation. Employee records. Many states give employees a right to inspect their personnel files. Contents vary. Medical files must be separate under the ADA. I-9s should be separate. Investigation files often separate. And here's the trap I've seen. An employer produces a personnel file in litigation and discovers medical information was filed in it years ago. That's an ADA violation, sitting in a folder, waiting. Let's finish the life cycle. Someone's leaving. What happens to the data? Start with access. Termination should trigger immediate deactivation of accounts, badges, VPN, cloud services, and any SaaS tool they touched. And here's the reality. Most organizations do the obvious ones and forget the long tail, the marketing tool, the project tracker, the shared vendor portal. I've reviewed access logs showing former employees logging in months after departure. Not maliciously, the account just still worked. Data return is next. Company devices back. Company data off personal devices, which is where containerization pays off. And departing employees taking data is a real problem, from customer lists to source code. Exit interviews and forensic imaging of devices in sensitive roles are common. Then, records retention. You cannot just delete an ex-employee's file. Tax records, benefits records, I-9s, EEOC requirements, and potential litigation all impose retention. And if litigation is anticipated, a hold applies. The employee's mailbox is a specific problem. Business continuity says keep it. Privacy says it's full of personal content. Best practice is a defined transition period with a delegate, then archive. And post-employment references. Most employers now confirm dates and title only. Defamation risk. So here's the closing question. Does your organization actually know what a departed employee's data footprint looks like? Usually not.